Okay, here's from Black's Law, 4th page 1028. Law. That which is laid down, obtained, or established. A rule or method according to which phenomenon or actions coexist and follow each other. That which must be obeyed and followed by citizens. Get that? Citizens, subject to sanctions or legal consequences. Well, why must it be laid down? You see, what about unwritten law? There's an unwritten law, Mama's law, that you can't hit your friends, you can't hit other people, you can't steal their stuff. Black's Law would like you to believe that it has to be written for you to have to abide by it. And yet, this country was founded on English common law, and English common law, by and large, for a huge extent of it, is unwritten law. Statute, an act of the legislature declaring, commanding, or prohibiting something. Right? The written will of the legislature. The word is used to designate the written law in contradistinction to the unwritten law. So at least we're recognizing there is such a thing as unwritten. Okay, this is a paper written by the University of Berkeley. It's a very good description of common law versus civil law. Common law or civil law. The common law tradition emerged in England during the Middle Ages and was applied within British colonies across continents. The civil law tradition developed in continental Europe at the same time and was applied in the colonies of European imperial powers such as Spain and Portugal. Our legal system, which is based on English common law, our system is common law. The most fundamental ways in which they diverged was in the establishments of judicial decisions as the basis of common law and legislative decisions as the basis of civil law. We're wronged. Common law is generally uncodified. Uncodified. Okay? No code. Uncodified. This means that there is no comprehensive compilation of legal rules and statutes. Civil law, in contrast, is codified. So whenever you see a whole bunch of codes, you're dealing with civil law, not common law. Substantive law establishes which acts are subject to criminal and civil prosecution. Substantive law is written law. Same article. Historical development of civil law. The term civil law derives from the Latin ius civili, the law applicable to all Roman cives, or citizens. Okay, so it applies to citizens. Of legal scholars throughout Europe adopted the principles of ancient Roman law in the corpus iuris civilis to contemporary needs. The birth and evolution of the medieval civil law tradition based on Roman law was thus integral to European legal development. So you get it? Codes are Roman civil law. Our system of law is from English common law, not from Rome. France's civil code, known as the Napoleonic Code of 1804, such codes shaped by the Roman law tradition are the models of today's civil law system. Okay, this is the law of the land. This is the definition, law of the land. Everything which may pass under the form of an enactment is not the law of the land. Get it? Statutes are enactments, not the law of the land. When first used in Magna Carta, the phrase probably meant the established law of the kingdom, in opposition to the civil or Roman law. So civil and Roman law are not law of the land. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, of which shall be made under the authority of the United States, shall be the supreme law of the land. It means due process of law warranted by the Constitution, by the common law adopted by the Constitution, or by statutes passed in pursuance of the Constitution. Okay, and then from Black's Law 4th, 1968, sovereign, a person, body, or state in which independent and supreme authority is vested. A chief ruler with supreme power, a king or other ruler with limited power. Citizen, and what that